The power to make a will is the creation of law, and every power that is created by law has its limits. The power must be exercised as prescribed by the law. I recall that Pirelli used to have an advert that said, "Power without control is nothing, absolutely nothing." Under Nigerian laws, particularly under the Wills Act and the Wills laws that are applicable in many southern states, a testator has broad testamentary freedom. And this includes the freedom, the right to exclude anyone that he or she does not want from his will. Therefore, a testator can exclude a spouse, a child, a relative, or any other person from benefiting from their estate. Secondly, a testator has the freedom to gift his or her assets to non-family members. Therefore, the testator can bequeath assets to a paramour. I'm sure you ask me what it means. A secret lover, that's a paramour. She or he can gift to friends, to religious organizations, or to charity, as he or she desires. And then the motive for doing so is irrelevant. The courts usually do not inquire into the motives behind a will or the contents thereof. However, this right is not absolute. There are limits to it. The courts in Nigeria have delineated exceptions to this power in order to protect spouses and children, particularly under the following doctrines, one of which is the moral obligation that a testator owes to dependents. Where a testator had a legal or moral obligation to support a dependent, the total exclusion of such a person may be deemed contrary to public policy. And I'll just give you a simple example. If you have an autistic child whom you know is unable to cater for himself, but because you had a quarrel with the wife or you're angry that the wife bore an autistic child, you therefore exclude that child from your will, the court will look into it and favor that child. Thus, where there are moral obligations or legal obligations, a testator cannot avoid it by simply saying, "I have the power to make a will."